Hi, I'm Andrei Mincov, the founder and CEO of Trademark Factory. And in this video, I will talk about major amendments that are about to significantly change Canadian trademark laws.
Get it trademarked with Trademark Factory.
It's been a very long wait. For years, Canada has remained one of the few civilized countries that is not a party to the international treaty that allows business owners to file what is typically called an international trademark application. So what this means is that companies outside of Canada cannot protect their brands in Canada through a centralized international filing system, and up to this day have had to resort to using Canadian trademark agents to file their trademark applications in Canada directly. And what this also means is that Canadian businesses that target worldwide markets cannot take advantage of the international filing system either. So up to this day, they either have to set up operations in a different country, typically by incorporating a separate company in the US, or file dozens of trademark applications with their legal bills for trademarking going through the roof. Canada's current isolationist system benefits a very particular contingent: large Canadian law firms who readily take advantage of international businesses that are seeking to protect their brands in Canada. For decades, large Canadian law firms were lobbying against Canada moving towards unification of its trademark laws with the rest of the world. And their reasons are simple and easy to understand. They get a lot of their business filing trademarks for American companies who would otherwise be able to file their Canadian trademarks without using Canadian trademark agents. So finally, in 2014, Canadian government introduced a bill that offered many long-awaited changes to the Trademarks Act. Some of them came into force immediately, but most of them are only to come into effect once the government adopts regulations to clarify some of the provisions of the law. And at first, these regulations were expected in 2015. Then they were promised by the end of 2016. Now everyone's saying they will definitely come into force in late 2017 or maybe early 2018. Problem is, nobody saw these regulations until June 19th of 2017, when the government finally published the draft regulations inviting the public to provide their feedback. So in this video, I will not go through all little changes. I'm only going to cover those that actually matter to business owners and their branding strategy. As I mentioned before, a lot of the public comments that you may find online, so these comments come from big law firms. So don't be surprised that a lot of them are negative because they're in a panic mode, right? In fact, most of these changes are going to make the lives of business owners in and out of Canada much easier when it comes to trademarking. So what are the changes? First of all, the biggest deal, of course, is that Canadians will finally be able to file international trademark applications. What this means is that a Canadian individual or a Canadian company, after filing their trademark application in Canada, can file an international application for the same trademark and simply put check marks next to countries where they want to register their trademarks. The international application is filed in one language. You're not wasting money translating your applications to and from all sorts of languages. The fees payable to the Trademarks Office around the world are much lower. You don't need local representation in each country to file there, and it takes less time for your trademark applications to go through because the deadlines are also unified, unlike when you have to file your trademark in each country separately. The same would apply to non-Canadian companies and individuals. They would be able to add Canada to that list of countries where they want to protect their brands, and it will be a lot easier for them to do it because in this case they don't have to find somebody directly in Canada to get their trademarks protected here. Now, this is a massive improvement of the current situation. Suffice it to say that my own company, Trademark Factory, we were forced to file for our trademarks individually in many countries, which cost me a pretty penny. I'd rather spend building my business. Number 2, use will no longer be a requirement for trademark registration. So the current situation is that in Canada, your trademark will not register until you have declared to the Trademarks Office that you are already using your trademark for all products and services listed in the application. So this is about to change. No more trademarks based on proposed use. No more declarations of use. You file your trademark, and unless it gets opposed, it will be registered. This shifts the burden of protecting one's brand from the government to business owners themselves. And this makes perfect sense. If a business owner does not care enough to protect their long-standing brand by registering it as a trademark, why should the Trademarks Office care, right? This doesn't mean that Canada becomes a first to file system that exists, for example, in Europe. So if you had been extensively using your brand before somebody else runs to the Trademarks Office and trademarks your brand, you can still win, either through opposition proceedings or in court. And some say that the new system would make it more difficult for owners of unregistered trademarks to enforce their rights against those who apply to register those trademarks in their own name. But and actually some even lovingly refer to them as trademark trolls. And today I say boo-hoo. I mean, if you don't think your brand is valuable enough for you to trademark it, especially when it's so easy and relatively inexpensive to do it, you really don't deserve to have the whole legal system geared up towards protecting your rights against those who choose to use the system designed to let brand owners protect their assets. Seriously, if you leave your wallet in the middle of a public square, don't blame the mayor and don't blame the chief of police who might, just might, refuse to compensate you for whatever was in your wallet when you decide to come back to that square 5 years later and demand justice. Right? The new system will make it easier for brand owners to protect their brands. So instead of complaining how much more difficult it will be for you to protect your brand without using the system that's specifically designed to help you do just that, use the system and protect one of your most valuable assets. Number 3, it will become easier to register trademarks that relate to the shape of your physical products. So for example, think of the shape of the legendary Coca-Cola bottle, right? So it's both a shape of a product and it's also a trademark. So they trademark the way their product looks like. So in Canada, these used to be called distinguishing guys. And there was all sorts of special rules about them. So these rules are gone. The name distinguishing guys is gone. They will be treated the same way as regular trademarks. If the shape of your product can function as a trademark, in other words, if the shape of your product allows your customers and potential customers to tell your products apart from identical or similar products of everyone else, if it's so recognizable, then it can be registered as a trademark with a lot less formalities than before. Number 4, like the rest of the world, Canada will adopt the NICE classification of goods and services. And when I say nice, I don't mean nice as a, oh, how nice. I mean nice for the city. So Canada will adopt the NICE classification of goods and services, which divides all goods and services into 45 categories called classes. There are 34 classes of products and 11 classes of services. All applications will need to classify the goods and services for which the trademark is being filed. All applications will need to classify the goods and services for which the trademark is filed into these 45 classes. And Canada already started doing this. In fact, if you filed your trademark application in the last year or so, you would notice that it was assigned this or that class. The reason it was done is that it was impossible to integrate Canadian trademark laws with the international filing system without switching to the class-based system of trademarks, because that's how the rest of the world does it. One thing that will be different is that the government filing fees will be based on the number of classes in which you are seeking registration. And these fees are going up significantly compared to what they are today. Today, when you file a trademark in Canada, no matter how many products and services it covers, you are paying a single government fee of 250 Canadian dollars. Plus, you're also paying 200 Canadian dollars to get the trademark registration certificate after your trademark application is allowed. So, things are about to change. First of all, because there is no use requirement anymore, the allowance stage of the process is effectively gone. So if no one opposes your trademark, if you win the opposition proceedings, instead of your trademark being allowed, it will proceed straight to registration. This means that there will not be post-allowance government fee of 200 Canadian dollars anymore. That's gone. However, the filing fees will be based on the number of classes and services for which your application is filed. It will cost 330 Canadian dollars for the first class and 100 Canadian dollars for each further class. So if your application is in a single class, you're going to save $120 compared to today. So $330 versus $450. If your application is in two classes, you're saving $20. Again, $430 versus $450. And if you're filing your trademark in three classes, you're looking at 530 Canadian dollars versus 450 and so on. 530, 630, 730, and so on. Now, if you have a brand that you think would cover many products and services, I strongly recommend that you file your trademark application as soon as possible. This way, you can cover all possible products and services for a single fee of 250 Canadian dollars. Then, by the time your trademark application is past the opposition stage, the new regulations will probably be in effect, and you will not be required to show use, and you will not be required to pay the government post-allowance fees per class. So in theory, you can have your trademark cover all 45 classes for only 250 Canadian dollars. Beware, however, that even though there is no use requirement for registration, your trademark can be canceled for non-use if you have not been using it for a consecutive period of 3 years. So the value of such registration in 45 classes may be questionable. Number 5, the term of registration will drop from 15 years to 10 years. This is also to put Canadian trademark laws in line with those of most other countries. If anything, this should be another incentive for business owners to get their trademarks registered as soon as possible, because they may just be able to secure that 15-year term for the last time. Even though this provision introduces a shorter limit, it's not really that much of a big deal, if you ask me. If you have been in business under your brand for 10 years, paying a renewal fee should be the least of your concerns. So basically, in 30 years, instead of paying a few $100s twice, you'll be paying a few $100s 3 times. Big deal. Number 6, Canada will have divisional applications, which may come handy in case a part of your application is smooth and non-problematic, and some other part of it raises a concern of the trademark examiner. So today, businesses face an all or nothing proposition. They either have to convince the trademark examiner that the whole mark is registrable as is described in the application, or get rid of the items that cause concern. With divisional applications, you would be able to proceed to registration in respect of non-problematic parts of your application and continue fighting over the rest. Number 7. Unfortunately, number 7 is non-news. It's something that should have been changed but wasn't. The amendments do nothing to do away with Canada's unique official marks, superpower marks that trump regular trademarks and that are available to any university or any public authority. they can just come and grab whatever they want. And these official marks not only trump regular trademarks, they confer protection that is not limited to specific goods and services, as in the case of regular trademarks. So such trademarks don't expire and cannot be canceled, even if the entity that owns them has no further interest in the mark, even if that entity does not exist anymore. Why universities and government entities should be allowed to hold hostage business owners who come up with brands that have nothing to do with education, nothing to do with the functions of those government bodies, is really beyond me. If anything, I would really like the amended Trademark Act to strip away the right of universities and public authorities to disregard the usual provisions of the trademark system. Now, I have long been saying that the cost of trademarking is irrelevant. If your business makes it, your investment in protecting your brand will probably be your best investment ever. If your brand flops, if your business flops, then $1 you spend on trademarking would be $1 too much. But we don't start our businesses expecting our businesses to fail. On a grand scheme of things, saving a few $100s on your trademark application should not be the reason for your decision to trademark or not trademark your brand. If you're a responsible business owner, you owe it to your business to protect its brand. But having said that, now, because of all those changes that I just talked about, now may be the perfect time for you to go for registration of your trademarks before the government fees skyrocket and before the term of protection is shortened and before the trademarks office is swamped with all of the questions that will inevitably arise as they have to figure out how the new system will work. And once the regulations are enforced, consider seeking international protection through the international treaty that Canada is finally joining. So if you're a Canadian company, consider, again, when those regulations come into force, consider filing your international trademark application to protect your brand outside of Canada. Maybe you need US, maybe you need Europe, maybe you need Africa, maybe you need Asia. All of that you can do from Canada in English. Wouldn't that be great? And if you're a business outside of Canada and you didn't want to deal with Canadian trademark agents directly, again, you will be able to add Canada to your list of trademarks that you protect internationally. It will be very exciting times for trademark owners. And I invite you to be a part of this. I invite you to do whatever it takes to make sure that no one even thinks about ripping off your name, your logo, your tagline. It's going to be an exciting time that will allow you to protect your brand easier than has ever been before. Are you going to be a part of this?